The Rome Statute, which governs the International Criminal Court, states that the place of trial shall be the seat of the court. But Deputy President William Ruto is seeking to be allowed to have his trial proceed without him being constantly present at the Hague-based court, mainly because of his responsibilities as a deputy president back home in Kenya. This was the mainstay of today's legal debate at the courtroom.
This is a right to be present, not a punishment, to be in detention almost. And, Your Honours, for the reasons we stated in our motion, we say it's absolutely justified, will enhance rather than diminish the proper administration of justice.
A criminal trial, in absence of the accused person, just like their participation in the proceedings via video link, is a concept that is unknown in traditional model of international criminal proceedings.
At trial, the expectation is that the accused is present. If he's not present, the impact or the extremely negative impact in this position would be as to the victims and to the witnesses. If I can expand on that more, it would specifically be the victims need to have assurances, again, that this process is a serious process, that these are serious allegations.
Normally, what's said is it's scary, it's fearful, a witness is somehow constrained sometimes if a perpetrator is before them. So if anything, it should even be, if of course these are completely and utterly denied as rubbish, as nonsense, but even from that perspective, those that are representing victims and witnesses should feel even more emboldened, not constrained, if there was a scintilla of reality, a scintilla of truth in any of those submissions.
Would you consider even partial absence of the accused as a significant harm to the integrity of proceedings?
Yes, we would object to any partial absence of Mr. Ruto throughout the trial proceeding. To elaborate, we first look at Article 63, which uses the word shall be present, and we believe that that's the plain reading, that's the intention, and that should be adhered to.
It has been explained that the relation of rules of practice to the work of justice is intended to be that of a handmaid rather than mistress. And the court ought not to be so far bound and tied by rules, which are, after all, only rules of general procedure, as to be compelled to do that which would cause injustice in a particular case.
My client instructs me to clarify and make it clear to the court that he intends to attend the court. He appreciates that it is a right given to him, and he intends to exercise it by being present throughout the trial.
Besides seeking relief to waive his right to attend trial sometimes, Ruto also made an alternative application to attend trial via video link.
The waiver will also contemplate that there will be no quarrel later, that because of video link technology or its failings, that your client was not able to follow or do something or other. Is that the case?
One only needs to have the objectives of representation from the client. The strategy and every other matter we will pursue ourselves in court. So, Your Honour, there won't even be a delay of seeking to get instructions unless there's something unforeseen in very unexpected circumstances, and that can be done immediately by phone. So it will not delay proceedings. It will, hopefully, things will work even more smoothly.
The court retreated into a private session to address the matter of investigations by prosecution into allegations of witness interference and bribery. Sylvia Chebet, Citizen Live at 9.